Hi folks, Dave Waring here again with FitSmallBusiness.com and today's lesson of the day. In our last video, we continued our series on how to start a successful business with a look at how to put together a partnership agreement. In today's lesson, we're going to continue that series with a look at how to choose a legal structure for your business. So let's get started. The business structure that you choose affects everything from how your earnings will be taxed to how much personal liability you have when something goes wrong with your business. If you choose the wrong structure for your business, you could not only end up paying more of your hard-earned money away in taxes, but could also be putting your personal assets like your home at risk. Here are the primary factors to consider when choosing a business structure. How much personal liability will you have for the business? How do you want your earnings and profits from the business to be taxed? How easy is it to set up? How it affects partners and the business's ability to raise money. Now let's evaluate each of the primary business structures based on these factors. A sole proprietorship is the simplest business structure. In fact, you don't even have to do anything to set it up. If you're providing a product or service to the public, do not have any partners, and have not set up any other legal entity for the business, then you are automatically a sole proprietorship. There is no distinction between business and personal from a liability standpoint. You are personally liable for any mistakes, debts, etc. that are incurred by the business. If you're selling arts and crafts online, then this may not be a big deal. If, on the other hand, your business involves taking on a lot of debt or removing large trees from beside people's houses, then this is likely a large issue. With a sole proprietorship, you pay taxes on all earnings of the business, revenues minus expenses, and cannot pay a portion of the money over and above your salary out as a distribution, which is generally taxed at a lower rate. You pay a similar income tax rate on money from your sole proprietorship as you would pay had the money come from an employer. This is the easiest business structure to set up. No paperwork required to set up as a sole proprietorship. If you want to do business under a different name from your own, you will need to register a Doing Business As form, or otherwise known as a DBA, which you can learn more about on the Small Business Administration's website at sba.gov. You generally will not be able to raise money from outside investors as a sole proprietorship. Sole proprietors do not have partners. The equivalent of a sole proprietorship with partners is a general partnership, which we will discuss next. What's the bottom line? For businesses that have no partners and do not have the potential for large legal and/or financial liability, starting as a sole proprietorship may not be a bad option. However, once the business starts growing, you are likely going to want to change to one of the other entities outlined below. General partnerships. Like a sole proprietorship, a general partnership is a very basic business structure. If two or more partners agree to do business with each other and do not set up another type of business structure, then they are automatically a general partnership with no official paperwork required. There is no distinction between business and personal from a liability standpoint. This is an even more important point with general partnerships because you are liable not only for yourself but also for your partners. So, for example, if one of your partners goes out and runs up a lot of debt for the business or makes a mistake and the business is sued, then you are liable as well. Like sole proprietorships, general partnerships are taxed only at the personal level, and all income from the general partnership is subject to taxation, regardless of whether it is left in the business or paid out to the partners. You pay a similar tax rate to what you would had the money come from an employer. There's no paperwork required to set up as a general partnership unless you want to do business under a different name, in which case you need to file a Doing Business As form with your state. Although not required, it is highly recommended to put together a partnership agreement for general partnerships, which you can learn more about in our video on partnership agreements. You will generally not be able to raise money from outside investors as a general partnership. Unless you have a partnership in place to the contrary, any partner may decide to dissolve the partnership at any time for any reason, and the partnership automatically dissolves should one of the partners declare bankruptcy. What's the bottom line? Because of the additional liability and potential disputes that arise under a general partnership, we do not recommend operating as a general partnership. If you do not have the funds currently to set up as one of the other business structures below, then at a minimum make sure you set up a partnership agreement. A limited liability company, or LLC for short, separates the individual and the business from a liability standpoint and provides a lot of flexibility in how the business is run and taxed. It is therefore generally the first entity that should be considered when setting up a business structure. An LLC business structure treats the individual business owners and the business separately from a liability standpoint. In this way, LLCs act like a corporation. After setting up an LLC, if no election is made with the IRS, then income from the LLC will pass through to the owners in the same manner as it does with a sole proprietorship and general partnership. However, LLCs can also elect to be treated as a C Corp or an S Corp from a tax standpoint. We discuss how C Corps and S Corps are taxed later in this video. You will have to file paperwork with your state to set up an LLC. However, there are many online services like rocketlawyer.com and LegalZoom.com that can help you do so, and it's not very burdensome. Along with the state filing fees, it should generally be less than $500. Choosing an LLC will likely not prevent you from raising money unless you or those investing in you are planning on taking the company public. Most states allow what is known as a single-member LLC, so you generally do not have to have a partner in order to set up an LLC. Unlike a general partnership, LLCs are seen as a separate entity from their partners and can therefore continue to operate should one of the partners decide to leave the business. Like with general partnerships, however, there should be a well-crafted partnership agreement, which is called an operating agreement in the LLC structure, executed between the partners to outline how the business will be run and how any issues will be handled. What's the bottom line? LLCs offer the best of both worlds, liability protection, and the flexibility to choose how you'd like to be treated from a tax standpoint. They also require less paperwork and maintenance than a C corporation. For these reasons, they should generally be the first option considered when seeking a legal entity that provides liability protection. C corporations. The primary advantage to a C corporation over an LLC is the ability to raise money by taking the company public. If you do not plan on raising outside money in this manner, then the LLC offers very similar liability protection and much more flexibility from a tax standpoint. Like an LLC, a C corporation treats the individual business owners and the business separately from a liability standpoint. Income from a C corporation is taxed at the current corporate tax rate of up to 35%. Income that is paid out to shareholders in the form of salary is then taxed again at the recipient's personal income tax rate. Income that is paid out as dividends to shareholders is also taxed at the current dividend rate of up to 20%. If the corporation meets certain restrictions, it can elect to be treated as an S corporation from a tax standpoint in order to avoid double taxation. You can learn more about this when we discuss the S corporation later in this video. Like with an LLC, you must file paperwork to set up your C Corp. The initial setup and cost for setting up is similar for LLCs and C Corps, and you can use services like rocketlawyer.com and LegalZoom.com to set up a C corporation as well. However, there are ongoing requirements to maintain a C corporation that do not exist for the LLC. In most states, C corporations have to hold formal board and shareholder meetings and keep minutes of those meetings. Reporting your taxes also requires more paperwork with a C Corp than it does with an LLC. If you plan to take your company public, then currently you must be organized as a C corporation. Many venture capitalists also prefer to invest in companies which are organized as C corporations. The reason why is that there's greater flexibility of ownership in a C Corp versus an LLC or an S Corp. For example, with a C Corp, you could have more than one class of stock, which provides different benefits and authority to different types of owners. If you want to give stock options to employees, you will also need to be registered as a C Corp. C corporations are seen as separate entities from their partners and can therefore continue to operate should one of the partners decide to leave the business. There should, however, be a well-crafted partnership agreement, which is called a shareholders agreement in the C corporation business structure. What's the bottom line? Unless you're planning to raise a significant amount of money and or take your company public, an LLC structure gives you many of the same benefits with more flexibility than the C Corp. S corporations. Both LLCs and C corporations can elect to have their business treated as an S corporation from an IRS standpoint. This allows C corporations to avoid the double taxation issues. LLCs who elect to be treated as an S corporation can have money paid out to the partners over and above a reasonable salary treated as distributions instead of income, which can substantially lower their tax bill. In order for your LLC or C Corp to elect to be treated as an S Corp, it must be a domestic corporation, have only allowable shareholders, which includes individuals, certain trusts, and estates, and may not include partnerships, corporations, or non-resident alien shareholders. It must not have more than 100 shareholders, it can only have one class of stock, and it must not be an ineligible corporation, i.e. certain financial institutions, insurance companies, and domestic and international sales corporations. The S Corp is simply a designation with the IRS for tax purposes, so the liability is the same as it is for the underlying LLC or C Corp that elected to be treated as an S Corp. Shareholders in the LLC that are active in the business must pay themselves a reasonable salary, which will be taxed at their personal income rate. Money which is paid out to shareholders over and above this amount will be taxed as either a distribution or a dividend, which is generally a much lower tax rate. Unfortunately, there is no specific guidance provided by the IRS as to what a reasonable salary is. However, a good guideline is that if a non-shareholder would not accept the job at the salary, then it's too low. In order to be treated as an S Corp, you must set up your LLC or C Corp first and then file a Form 2553 with the IRS to elect to become an S Corporation. The reporting requirements for the S Corp are basically the same as they are for the C Corp. If you are an LLC, this increases your maintenance. If you plan on taking your company public, then you will need to have a C corporation when doing so. With S corporations, you can only have 100 shareholders who must be domestic individuals, and you can only have one class of stock. What's the bottom line? If you have an LLC, then there's no reason to elect to be treated as an S corporation until the business is producing enough profit to pay yourself more than a reasonable salary. Once you get to this point, then electing to have your LLC treated as an S corporation can result in substantial savings. If you have a C corporation and meet the restrictions for having an S corporation, then electing to be treated as an S corporation allows you to avoid the double taxation issue of a C corporation. That's our article for today. If you have any questions or comments, please leave them in the comments section below. Also be sure to stay tuned for our next video, where we will continue our series on starting a business with a look at patents and trademarks. For more great advice on how to start and run a successful business, be sure to visit us at fitsmallbusiness.com today. Thanks for watching.